Good day and welcome to this week's episode of Strictly Legal. It's Thursday, Holy Thursday, a blessed Thursday to you, Easter weekend. Of course, you are watching us live on WESN, Content Capital. I am your host, Rondell, Donawa, attorney at law. Once again, I'm happy to bring the law and you. Of course, today you can stream us live on WESN, CC on all social media platforms, including the podcast Strictly Legal with Rondell Donawa. Today we have a heavy topic. We are speaking about citizens and your rights in relation to law enforcement. A lot of times we see that persons are recording police officers in the execution of their duties, and we have seen just recently the Minister of National Security indicated that it can be a crime to record police officers as it is quote-unquote being obstructive or obstructing the course of justice. As well as many of you want to know, okay, what is your rights in terms of stop and search, whether police can just stop you with a warrant or without a warrant, in particular with property as well, when police are raiding, what they can and cannot do. And today we have a very special guest, Mr. Farid Ali, attorney at law, no stranger to TV, no stranger to the public. He has been practicing criminal law for the past 12 years. And during that time, he has had conduct of a few matters that was a subject of national attention given the seriousness of the offenses. And we have seen those matters quite often. Mr. Ali has worked in assisting the Legal Aid Advisory Authority with providing representation to minors who have been charged before the courts for criminal offenses. And then that includes serious offenses, minor criminal offenses, as well as major ones. He remains a strong advocate for passage of legislation that will allow persons remanded in custody for murder to be afforded the opportunity to access bail if their circumstances merit so. And we have seen recently where that has been so in terms of the Court of Appeal's decision. He has publicly stated that legislation in the jurisdiction of Barbados has allowed murder for bailable offenses, and now this exists in Trinidad. Despite the lack of political will, as he says, which continues to haunt the prison authority in providing the best facilities and amenities to those occupying the prison. He is an advocate as well for prison reform and all things to protect the constitutional rights of these inmates. And of course, today we are going to speak about citizens and law enforcement rights. Mr. Ali is in studio, so once again, good morning, Mr. Ali.
Good morning, Mr. Donawa. It's a pleasure to be here.
Indeed, and thank you for agreeing to come on this noble set where many of your colleagues, both senior counsel and not, have been sitting there. So thank you so much.
Well, I'm happy to have made the queue.
That's all right. So we're speaking about citizens and rights. I know you would have had discussions with respect to this particular issue, more importantly, when we're relating to police officers and citizens recording. But before we get there, let's discuss what is the role or what is the relationship between the police and the public in terms of law enforcement.
Right. I think we need to start by saying that the citizens of this country are guaranteed certain rights under the Constitution. The Constitution of Trinidad and Tobago, Section 4, speaks to 4A speaks to the right to life, liberty, security of person, enjoyment of property. It means to say that we as citizens of this country, not only do we have the right to live in this country, but we have the right to live and live freely. And freely simply meaning that no one can determine where we go and when we come. We determine our day. That 24 hours that we wake up to every morning, it's that 24 hours that lies entirely in our hands. You are only to be deprived of that ability to make those decisions concerning your life if it is the law sees it necessary to curtail that freedom, to stop the freedom, if it is under due process of law, you're caused to be remanded at a nation's prison for breaking the law. So let us evolve it in a different direction. Apart from that right to life, liberty, security of person, and enjoyment of property, you have the right within the law to uphold that innocence until someone can prove differently. So if the police raises an allegation against an individual, that allegation ought to be grounded in something factual and something substantial, and the police must have a reasonable basis for investigating an individual. It's not a random, arbitrary situation. It's not like, there was an expression in the 90s, we say, this is not Baghdad. This is not a situation, well, the references would change over time. So this is not the Ukraine where, a Russian could just simply move into your country and accuse you of any number of things, and then you must simply be on the back foot and concede. If an allegation is raised against you by a police officer that you're involved in theft or you're involved in an alleged murder, then the police must have a factual basis. They must have a witness, or they must have some sort of investigative literature or material that substantiates that position. You as an individual now may be detained by the police, brought to a police station and questioned concerning what the allegations are. Based on the information that is put to you, you, the individual, now can then respond.
Yes.
So if it is you have a clear alibi, you are being accused of committing a murderous act in Maruga, but you have an alibi that you were on Gattaca Street all of that morning that this murder would have taken place. So your alibi would clearly be your employees or the staff that works around you. They can come and give witness statements and give evidence that you were with them. So we're seeing the law at work in a very practical way. Allegations are raised, you get an opportunity to present your case.
Yeah.
It begins at a police station. And the police cannot deny you the ability to put that forward.
And let's deal with, and that is very interesting, because what I want to deal with now in terms of police, or in terms of police authority to stop and search an individual, let's say on the streets, what sort of legal authority that the police has? Can the police just stop someone just like that to question them or to search them? Or must they have some sort of reasonable suspicion?
All right. The police cannot profile an individual in the street and decide, because he's wearing an Islamic wear, or because he is a Rasta man with long locks, or his pants is falling off his waist, that let me give him a rub down. You can't see because it's a black boy coming up a side street, well, he could only be up to mischief given that it's 11 o'clock in the night. In other words, there must be facts to substantiate the stop. The police are free to stop and search if it is they have information or reason, or they form a reasonable opinion on looking at an individual that there's reason to stop them. So it's okay to profile someone. It's okay to see a man walking in the road, watching into people's yards, and not form the opinion that he's off to mischief. But if it is you see he's doing it with and there's an additional component that he's trying to open the gate,
yes,
then we may form the view now, well, he has advanced his position where it appears that he's looking to get into people's yard. Let us make a gentle inquiry of him as to whether he's lost, or if he lives here, or anything of the sort. So factually, the facts of the matter must support the reason for the stop. If the police cannot support the factual basis for their stopping and questioning, then it is wrong. So immediately at work, the law at work is there must be a factual basis, there must be a position where we've made certain observations and we form no opinion based on the observations. It could be based on your demeanor, the way you're conducting yourself in the road. It could be based on your appearance,
yeah,
or it could be based on the cocktail of your demeanor and your appearance and the way you're conducting yourself. That is enough to form an opinion. However, you must also form the opinion on a reasonable basis. It cannot be that I'm only targeting people in Islamic wear, or only targeting the little black boy, or I'm only targeting situations where it's clearly you're profiling persons. You're looking at one person with a prejudicial eye.
Yeah. And therefore the reasonable test is really an objective test.
It is, the reasonable test must be objective. But there's the only subjective component is that component that speaks to the facts that we're looking at. And yes, the facts is the situation and the circumstances. A man cannot be walking down Frederick Street with a hammer in his hand 2 o'clock in the morning and wielding it and saying that he's on his way to work. It may be, very well he may be on his way to work, but it's illogical that a tradesman will be walking, wielding a hammer in his hand in open space, not having it concealed. So factually, you form an opinion based on the fact that he is doing something that is unnatural. If a man is walking down the street naked, it's unnatural.
Yeah.
If it is a man is walking, following women in the street and looking at them in a certain way, or making conversation that is uncouth, then it's unnatural. So the police can form an opinion based on the report she makes or based on the observations they're making of him in that moment. So factually, the subjective element would be factually what the observation is.
Yeah.
But the reasonableness test is based on their opinion of his intention. And they will only come to the conclusion as to whether he's really up to something lawful or unlawful when they interview him.
And therefore, when it comes to, the police searching someone, in terms of what is force, can the police just use whatever type of force, whether it's assault by way of beating to a person who is not even reacting to an arrest? I mean, we've seen where individuals who are in the course of being detained would have resisted, and then the police use excessive force. So the question is, what is excessive force? Or can the police use such force on that individual?
If the police are investigating a crime and they approach an individual, it's always the first option to get voluntary information from the individual. So the police, they would have the right to ask the question. Based on their approach, they may get a response from the individual readily, meaning that the person is willing to assist with information. If the person volunteers information and the person is assisting the police in the question, through the line of questions that the police is engaging them on, then all is well. If it reaches the point where that individual refuses to empty his pockets, refuses to open his coat, refuses to take his hat off, and it appears to the police that there is something that the individual is trying to conceal, it is the position of the police to still ask of that individual, could you open your hat out? Could you take off your shoes and shake it? Could you take off your belt? And if the person is refusing, the issue comes to the point now, we are at that juncture where the police may have to get physical with the individual. But the physical that the police gets with you must be physical in terms of reasonable contact, using reasonable force. They can't hit your bellas, as we say on the street. They can't kick you in your belly, stamp you in your face.
But sometimes we see that happening.
And if that is happening, then that ought not to happen, and it becomes unreasonable, because what determines reasonable force is what threat the individual places to your person, meaning that the civilian you're engaging, if the civilian is unarmed, the civilian may be small frame like yourself, and you're dealing with a big burly police officer, let's say Inspector Alexander. Mm-hmm. He may not need to use all that amount of force on you. So you have to examine the circumstances subjectively as to whether you have 6 officers needing to hold on this one man, and why it is, even when the handcuffs are on him and they're placing him in the vehicle, they're still lashing him. All of that is clear signs of it's unreasonable force. The man has already surrendered. It's 6 of you, all he's in handcuffs, you're putting him in the Jeep, but yet still you have a 3rd officer hitting him a slap, ringing up his air, hitting him a cuff in the belly. All of that is symbolic of unreasonable behavior and unreasonable force.
And now, can the citizen, can the police be held to account for that sort of excessive force? What rights does the citizen have in terms of complaining or in terms of going to litigation to deal with this aspect of punishment?
Once you've been detained, and the next step after detention is to take you to the nearest police station, right? Once the police takes you to the nearest police station, the first thing that happens is when you enter the station, the officer in charge of the charge room, which is that area that is the public space. When you come into a station, that is the charge room where the public interacts with the police over the desk. In that charge room area, once it is declared that we've just brought in Rondell Donawa, and he has been detained for attempted robbery, that declaration must be made by the police to the police at station. So they declare that this is a suspect we've brought in here, a person of interest. They would then, the officer in charge of the charge room would now make a log as to Rondell Donawa has been brought in. Is under suspicion of robbery. He is 5'4", brown in complexion, medium below, clean shaven. And they have a physical description and a physical log of the individual that comes in. At that point, they ask of you, the individual, the police ought to ask of you, if you came here with any injuries, you, the individual, are free to say, these 2 officers now beat me on Gattaca Street. One cuffed me in my face, my front teeth loose, I'm bleeding, I need to get to the hospital. And at that point, the officer in charge of the charge room ought to ensure that you're taken to a medical institution. So when you arrive at station, for them to cover their backs, the officers on duty at the station, they ought to ask that question right away. you ought to be taken for medical attention at the station. So if it is you're beaten at a police station, if it is you're mistreated before you got to the station, you make that declaration at the station, and the station ought to take you for medical attention.
Yeah.
That medical certificate at a public institution is what you're going to use against the police. When it is you're going to bring a case now, a suit against the Trinidad and Tobago Police Service for the damages that they caused you on the streets. And then, of course, if it's done in full public view, the CCTV footage cameras on the street is going to pick up the incident. If persons videotaped that incident, because very often what we're seeing now is neighbors would see police up to no good.
Yes.
They draw their camera or they start videotaping. You're free to present that video evidence, and that will be used to help prove your case and substantiate that something happened. It's independent evidence.
And as we on that topic, let's deal with the use of recordings, because I know that just recently the Minister of National Security, as I indicated earlier, would have warned citizens against recording police officers, more particularly, as he said, why there's no law or policy to stop anyone from videotaping police officers while on a job. Obstructing them while recording videos could attract charges and penalties. And I know that you responded to this. Now tell us, is there any law preventing someone from recording a police officer or officers or law enforcement individuals in the execution of their duties?
There's absolutely no law that prevents any individual from videotaping the police. In fact, the video evidence that is presented on a day-to-day basis by way of the CCTV footage cameras the police themselves and Ministry of National Security set up throughout Trinidad and Tobago. That is the evidence that the police rely on in proving a case against citizens of this country. So it works two ways. The very same CCTV footage cameras, if that picks up and captures a moment where the police are acting in excessive force, then that evidence and the footage from that could be used against the police.
Yeah.
So in like manner, if it is members of the public with access to phones or access to cameras in their yards or security cameras as they may set up in their own communities, wish to access that footage, they can do that to prove a case against the police. Members of the public, we often see that persons are individuals quick to draw on their mobile device and start recording what is happening. In no way could that be illegal. If it is the police are doing things in the correct manner and they're executing their function and their duty in the correct manner, then that video footage from civilians who are taping could help vindicate the police and could expose that they were doing things in the right and correct way. There is no law that is being broken when citizens videotape. Now, Mr. Hines recently said that the police, in an instance where videotaping is being done, could charge an individual for obstructing them in the course of their duty. Yeah. We need to bear in mind, under the Police Service Act, Chapter 1501 of our laws in Trinidad and Tobago, 59 speaks about a person, and I'm quoting here, a person who assaults or obstructs or resists a police officer in the execution of his duty, or aids or incites another person to assault, obstruct, or resist a police officer, the police officer in the execution of his duty is liable on summary conviction to a fine of $1,000. So, yeah. Well, not 1,000, in fact, it's 10,000. So where we are is this. Mr. Hines is correct in quoting that provision of that legislation under the Police Service Act, but he's also misquoting and misapplying that piece of provision. That provision speaks to when an individual obstructs, assaults, and resists, aids and incites persons to block the police in executing an arrest or to obstruct the police in doing what they're doing. If an individual is videotaping, he's not obstructing the police. He's not preventing the police from fulfilling his function. If there's anything, that person's hands is occupied in another way. They're simply holding the camera up and videoing what the police is doing. In what way is that video component being engaged by a civilian, blocking the police from executing their duty? Is it that the person is coming too close to the police in holding the phone up? If it's anything, the police should be very, very secure about any video work being done because they know that they're fulfilling what they have to do in the right manner. It becomes an issue when the police doing the wrong thing, engaging the public in terms of being abusive, being loud, using unreasonable force, using obscene language, using annoying language towards the public. So the video component may in turn be an obstruction in terms of the police don't want the authorities to know, the rest of the public to see what they're capable of.
So it's important for the public to know that there's no law preventing you from recording police officers. And of course, it's important, and I mean, I know I would have spoken to you about this off air, that the former commissioner, I think, would have indicated that stay at a distance. You can stay at a distance. Once you're staying at a distance, you are not obstructing the police in the execution of their duties.
And simply, to put it another way, if it is an individual stays a reasonable distance, let us say 4, 5, 6 feet, there's no law that says what distance it is. It's a discretion. You're staying a reasonable distance and you're zooming in with your camera. Then that zoom is going to accommodate the distance between you and the individual, you and the police, you and the persons who are engaging the police. So you're capturing the image without even getting close to them. Mr. Hines, I believe, is simply being mischievous when it is he wants to apply that area of the law and saying that you're obstructing the police, because obstructing is a subjective thing. The police may find they're being obstructed, but the civilian is of the view that in no way am I obstructing. So the only way we can make a determination as to who is obstructing and who is not is to perhaps look at the video. And
obstructing, in my mind, is when you're literally in the middle of the police executing their duties. Like, for instance, we've seen videos recording of, I think in San Fernando, a schoolgirl was obstructing the police from executing their duties, arresting a gentleman as well. We've seen on other occasions where persons actually physically was obstructing police, but in no way that can amount to recording being obstructing police.
The intention is what makes it obstructing. If it is your intention is to record, that is not obstructing. What makes the difference between obstructing and not obstructing is the mind behind the video recording. The mind is not to obstruct, the mind is to record. So if your intention is to record, then you're not obstructing. If the police have the view that you're obstructing, then they must prove that. And your position would be that in no way am I obstructing if I'm intending to expose the wrong that you're doing.
Yeah.
And independent witnesses in and around who are able to offer similar evidence would help corroborate the story as to this individual was recording, and in no way was he within any close remit of the police doing what they were doing. Hines also spoke about the police can charge you for harassment when it is you're interfering or you're involved, when it is when the police is trying to arrest somebody. That are harassment. If we were to look at the Harassment Act, Act number 11 of 2005 speaks for the purposes of this section. A harassment of a person includes alarming the person or causing the person distress by engaging in a certain course of conduct. We must ask ourselves, in what way is video recording the police in their duty amounting to alarming them or causing them distress? You're not causing the police any distress. Mm-hmm. The police are about their business and you are simply making a recording of it. The law as it speaks to harassment and recordings talks about when you're following somebody around and you're making visual recordings and stopping them and accosting them in the road. That is another misapplication of the law by Mr. Hines, because under the Harassment Act, when the persons are video recording, it's to capture moments when you are stepping into somebody's personal space, obstructing them in the road and making physical recordings. That is a totally different concept to what is happening on the road when civilians are recording police who are doing wrong things.
And let's deal with the issue of damage to phones. We've seen where law enforcement officers would have taken persons' phones and throw it away and damage their phones. How can citizens get redress? Can they do that?
There is what we call the Criminal Damages Act, right? That speaks to Section 45. Any person who unlawfully and maliciously commits any damage, injury or spoil to or upon any real or personal property whatsoever, either of a public or private nature, for which no punishment is provided, the damage, injury, or spoil being to an amount exceeding $500 is liable to imprisonment to 2 years. So under the Malicious Damage Act, Chapter 1106, 47 of 1988, it speaks to a person who unlawfully and maliciously commits a damage or injury to another person's property. When police officers grab your device from your phone, or they burst your chain, or they cause any damage to your property, that in itself can be deemed a malicious damage. Under Section 45 of the very same Act, you, the citizens, have a redress against the police for damaging your device, for damaging your phone. The only reason, even if it is they suspect that your phone is being used in an effort to record them, the most they can do, the length they can take it to, the distance they can take it to, is to ask you to stop recording. And if it is you choose to continue to record, they still cannot take your device from you. But let us say they do so. They must justify for what reason they seized your device, and for what reason they had to throw it on the ground, or explain why they caused damage to your phone.
And of course, the definition of obstructing does not suffice, or it does not define why they do that. It does not justify, sorry. The defense of rather.
Even if it is they're obstructing you, all they can do is to ask you to desist from doing what you're doing. They cannot seize your property because that property isn't causing them any damage. And even if it is causing them any damage, they must have a reason to seize it. All they can do is issue instructions for you to stop doing it and explain to you why. But what we're seeing is when these incidents are taking place and there's confrontation between the police and civilians on the street, let us say it's a warrant they're trying to execute, let us say they're trying to quell a mob, reduce a riot to civil activity, the police have no opportunity in that moment to desist from dividing their time between doing that and stopping somebody who's recording. So for them to stop that and then see somebody's device, it shows that there's an extra intent or a reason that they want to seize in order to prevent that footage from getting a certain place.
Indeed.
So if they decide to escalate that into flinging the phone, pelting the phone, destroying the device, then that becomes malicious because there was no intention when they seized that to do anything lawful with it.
And you've mentioned warrants. I know quickly we're almost out of time in terms of warrants. Now, when police are entering properties, or rather any establishment, rather building rather, can they enter a building to search without a warrant, or there must be a warrant at all times, regardless of whether it's a building or a gallery, or it's an enclosed area or open space that is seemingly halfway closed but it's a private property? How does the law reflect in terms of that?
The police cannot enter any private dwelling house or any private building space, or enter anybody's vehicle parked in the road, or any personal property. They cannot engage or make contact with that unless it is they can do so by way of a warrant. And let me be more specific. Your dwelling house out there, a police cannot come into your premises and enter your house without your permission. You can refuse and say that I'm not allowing you to unless you produce a document that is a court order that allows me to, or that speaks to the fact that you're allowed to come in here and search. And that warrant, that document must speak to the name of the individual whose house you're coming into. It must speak to for what reason, what is the reasonable grounds you suspect that there's something illegally, and what it is you're coming to search for. So if it is, we are executing a warrant on our house, let us say in Kathleen Warner Street in La Joquita, we must have the name of the individual on the warrant. We must have the reasons for getting a warrant, meaning we believe that there may be property inside here, or you're engaging in some sort of trade, in some sort of activity that may be breaching the money laundering laws of Trinidad and Tobago. Or we may believe that there's guns and ammunition in this house. We believe there's drugs in the house. The warrant must say that. And the warrant must also carry an address. So the warrant must have a name on it, it must have an address, and it must have the reasons. And it must be signed by a justice of the peace and stamped. Unless those elements are not present, that warrant may not be a legitimate warrant. And police can only enter with a warrant. The only occasion a police cannot enter your premises, or the only occasion a police can enter your premises, is if it is they are coming there to prevent a crime. So if it is a husband is beating a wife, and the neighbor calls and say, I'm hearing the woman screaming down, and he talking that he want to kill her, and she's screaming, oh God, then when the police can respond, come to your house, they can enter without a warrant, because they're coming there to prevent a crime. Mm-hmm. And the time it's going to take to get a warrant, to go and swear an oath and get a JP to put a stamp on a document, the man kill the woman. Yeah. So the police can enter premises to prevent a crime if they believe that a crime is taking place in that moment. So in order to save lives, they enter without a warrant, and it's understandable and lawful. But anytime you just want to come to stop and search, or you come on a fishing expedition to try to find something, you hear a story that, you know, he have unlawful money inside there, he has guns, he has ammunition, you need a warrant.
And quickly, just in 1 minute, can you just state how can citizens find redress in terms of complaints, whether they can go to the police complaints? Tell us how quickly they can
if it is the police comes into your house and they don't have a warrant and they break and enter, and they seize and they cause damage to your television, they rip down your wardrobe door, they open up your cupboard space, they fling clothes on the place, they mash up items, you're free to go to the police complaints authority and indicate.
And that's any type of obstruction, but any type of altercation with the police officer?
Any altercation with the police, you're free to go to the police complaints authority, which is building D on Rising Road, next to the Hyatt building, and you indicate to them, listen, I have a complaint to make. There's a complaints section there. They greet you, they speak with you, you explain to them exactly what happened. They take all the information and they assign an officer to the matter. The officer now will be in contact with you personally and otherwise. That officer will call the police station and inquire as to who was on duty and so on. So the exercise took place on this place, and they will determine whether there was any official log of any activity taking place. If it is, when they check the station diary and they check the log in the station, realize that we had no reason, or we have no recording of something, of a warrant being executed in somebody's house, or a search taking place at Mr. Donawa's house, and it's not recorded there, then that in itself is evidence that those police may have been up to mischief, because everything they do in their official function ought to be recorded in the station. So that's the first point of entry, that something illegal took place or something happened that was unauthorized. And citizens, when they make that complaint to complaints authority contacts the station to determine whether the incident was recorded. All right,
Mr. Ali, we have to close. I think we need to come back again, because another topic we need to discuss is malicious prosecution in terms of redress. So thank you so much, Mr. Ali, for gracing Strictly Legal. And I told you the 30 minutes will go quickly.
It's a pleasure being here. I'm happy to assist.
Indeed. So it's a wrap, guys. You have been watching Strictly Legal on WESN, Content Capital. I am your host, Rondell, Donawa, attorney at law. Please have a safe, holy, and enjoyable Easter. Happy Easter to you and the Christian community. Please be safe. COVID-19 is still out there. See you next time. Goodbye.